There's a moment in billion-dollar class actions where everything boils down to a spreadsheet. One mistyped join, one opaque model, one shaky assumption, and a putative class covering hundreds of millions of transactions can vanish. What do appellate judges actually look at when they're deciding whether an algorithm drove price increases class-wide? Stick around. The answer is technical, brutal, and often decisive. Over the next several minutes, I'll pull back the curtain on how federal appeals courts evaluate algorithmic pricing evidence in nationwide class certification fights, using the Live Nation versus Ticketmaster and Apple App Store litigation as running examples. You'll hear what types of data and expert work persuade judges, what mistakes kill certification, and a concrete checklist plaintiffs and defendants can use in their next brief. Quick disclaimer, this is educational content only and not legal advice. If you're dealing with a real case, talk to a licensed attorney. Federal appellate review of certification decisions often focuses on Rule 23b-3's predominance requirement. The key question is whether plaintiffs can prove the essential elements of their claims with common evidence across the class, or whether individualized issues will swamp the case. Appellate panels don't buy headlines. They ask whether the district court actually tested the plaintiff's economic model against the predominance question. In practice, that means judges want to know, does the expert's model yield class-wide answers about liability and damages under a plausible legal counterfactual? This matters because algorithmic pricing, cases dynamic fees, platform commissions, resale markups depend on reconstructing what prices would have been without the conduct. If the damages model can't produce that counterfactual in a way that applies to all putative class members, predominance fails and the certification order is reversible on appeal. Up next, the single technical issue that most often sinks a class data linkage. Judges obsess over whether plaintiffs can actually identify class members and link them to the alleged overcharged transactions. In the Apple and Live Nation fights, courts focused on whether databases are clean and joinable. The practical question is simple. Can every transaction be matched to a confirmed purchaser or device account under the class definition? If the data contain duplicates, mislinked records, or missing unique identifiers, courts have decertified classes, even ones alleging hundreds of millions of tickets or app purchases. A few percent mislink rate across a massive set produces millions of suspect transactions. It's not just whether the plaintiffs can match records, but whether the defendant or an independent auditor demonstrates material flaws. Courts have reversed certification where defendants expose coding errors or sample contamination. If data linkage survives, the next hurdle is the damages model, and that's where black box experts face the toughest scrutiny. A damages model that merely produces a big number isn't enough. Appellate courts want a model that maps directly to the legal theory of liability and generates class-wide, estimable damages under a plausible counterfactual. That requires three things: a clear counterfactual, a transparent methodology, and robustness. Judges ask first what prices would have been absent the conduct, second, whether the model assigns a damage estimate to each transaction or consumer rather than just offering an aggregate back of the envelope, and third, how sensitive the result is to key assumptions. In the Apple decertification, the judge found plaintiff's damages model relied on shaky imputations and couldn't show class-wide damages reliably. Regulators and plaintiffs may claim billions in fees and overcharges, but appellate judges focus on whether those numbers survive economic scrutiny, not press headlines. If an expert ignores plausible individualized offset defenses or assumes away heterogeneity among consumers, an appellate court can say the district court abdicated its gatekeeper role. Next, how courts treat algorithms and expert explanations. Algorithms are powerful tools, but courts demand explainability. An expert who testifies the algorithm raised prices without showing the empirical mechanism and transaction linkage is running on fumes. Appellate panels repeatedly criticize black box work, opaque code, proprietary models, or undisclosed parameters. What persuades a judge is reproducible code under a protective order, full access to raw transaction logs, clear variable definitions, and step-by-step explanations of how algorithm outputs were translated into damages estimates. Counter-experiments matter too. Placebo tests, falsification checks, and alternative specifications that show the result isn't just a product of one statistical trick. Courts will accept advanced econometrics, but only if the expert shows it is standard, peer-reviewed practice, or at least widely accepted in applied work. Novel techniques without careful validation raise reliability flags. So what happens when defense experts tear holes in the record? Defendants win appeals by showing material flaws in plaintiffs' evidence. Effective appellate strategies include independent data audits that reveal misjoins or duplication, sensitivity analyses showing results collapse with minor changes, exposing implausible imputations for missing data, and demonstrating individualized defenses that would require mini trials for each class member. Courts don't need to resolve every factual dispute on appeal, but they will reverse if the district court clearly failed to test plaintiffs' models for reliability. For example, showing that a dataset's unique purchaser ID is actually recycled across accounts can be dispositive. Similarly, demonstrating that damages depend on a small subgroup of transactions, like VIP sales, that aren't representative can defeat predominance. Appellate panels sometimes accept limited remands for narrow evidentiary fixes, but they also increasingly decertify when methodological defects go to the heart of class-wide proof. So what should plaintiffs do differently? Here's a practical checklist. Plaintiffs must build reproducibility, provide raw transaction tables under protective order, release code and syntax, show the counterfactual clearly, and run extensive robustness checks including leave-out subsamples. Address likely individualized defenses head-on and show why common proof can bridge those gaps. Defendants should prioritize data audits and targeted attack points. Can you show a mislink rate that materially distorts results? Can you demonstrate that a key assumption is unsupported empirically? Use short demonstrative simulations and briefs to show how small errors can cause massive swings in damage estimates. A short checklist for plaintiffs. 1. A clean, well-documented dataset with unique IDs and joint statistics. 2. An explicit legal counterfactual mapped to the model. 3. Row-level damages assignment rather than only aggregate numbers. 4. Reproducible code and full model specification. And 5. Robustness and sensitivity analyses including placebo tests. For defendants, 1. Commission an independent data audit and produce a concise defects memo. 2. Run alternative specifications to show instability. 3. Identify individualized defenses and quantify their scope. 4. Highlight any opaque or proprietary elements in plaintiffs' models. And 5. Push for an evidentiary hearing on expert methodology. Appellate briefs that win don't just repeat the record, they point to specific legal errors and attach the most probative exhibits. Remedies matter. Appellate courts are skeptical about sweeping nationwide injunctions or restitution remedies when the evidentiary record doesn't support class-wide harm or when the remedy intrudes on policy questions. Parallel enforcement actions supply factual context, but appellate courts still focus on whether the class evidence itself proves common harm. Cross-jurisdictional developments influence strategy too. Market analyses can vary by forum, so panels look to whether U.S. models are tailored to U.S. consumers and legal standards. An appellate win for plaintiffs is possible, but only when the district court can point to rigorous, transparent, class-level proof rather than press clippings or aggregated headlines. Quick recap. Appeals courts decide class certification fights by asking whether the district court tested the plaintiff's models against Rule 23's predominance requirement. Data linkage, transparent counterfactuals, row-level damages, reproducible code, and robust sensitivity checks are the holy grail. Opaque models, mislinked data, and fragile assumptions are fatal.